So I would wish to extend a special welcome to our distinguished panelists and our presenters for today. The Right Honorable Sir Charles Dennis Byron, who's the former president of the Caribbean Court of Justice and currently the president of the Commonwealth Judicial Education Institute. Also, we have the Honorable Mr. Justice Adrian Saunders, who is the president of the Caribbean Court of Justice, the current sitting president. And I think we also have the Honorable Mr. Justice Peter Jamadar, who is a sitting member of the Caribbean Court of Justice. I'm very grateful to all three of you for assisting us with our training program. We are indeed fortunate to have such eminent and accomplished jurists who are leading off our training sessions. Each of them have had extensive experience in implementing the CPR in courts throughout the Caribbean. And I'm very much looking forward to their presentation. Let me give you a little context. We in the Bahamas are currently operating under the rules of the Supreme Court, which were promulgated in 1978. That's 43 plus years ago. The only major legislative intervention that we've had in our rules since they were promulgated in 1978 was in 2004, almost 18 years ago, when Order 31A, the case management module, was inserted into our rules. And so we now continue to operate under a regime which is almost 45 years old. Therefore, today, this virtual seminar is a significant event in the context of the administration of justice in the Bahamas, as we mark the first step in the final stage of promulgating an entirely new code for the conduct of civil litigation in the Supreme Court. Again, just to give you a little bit of context, we are late to the table here as a jurisdiction. In England, the CPR was introduced in 1999. In Jamaica, the CPR came into operation on the 1st of January, 2003. In the ECSC, the Eastern Caribbean Supreme Court, the CPR was introduced in the year 2000, when I think Sir Dennis was the sitting Chief Justice at that time. In Trinidad, the CPR came into effect on the 1st of September, 2005. In Barbados, the CPR came into operation on the 1st of October, 2009. And most recently in Guyana, the CPR came into effect in 2016. And so you can see that the Bahamas is somewhat behind the curve, and it is a major part of my court modernization and reform initiative, which I launched upon taking office, to modernize our rules and to introduce the new CPR for the conduct of civil litigation in the Bahamas. Virtually all of our regional neighbors have done this, and the CPR is now, has now been adopted by most common law jurisdictions throughout the world. I think it is time for the Bahamas to now promulgate the new CPR and to start operating under this procedure. I'm sure you all remember that Lord Woolf, back in 1996, was really the father of the new civil procedure model. And when he introduced the CPR in England, he stated that its objective was to improve access to justice in three principal ways. One, Lord Woolf said, reduce the cost of litigation. 2 was to simplify the procedural rules and to modernize the terminology so the average person can understand it. And 3, Lord Wolf said, the objective was to remove unnecessary complexities in the litigation process and to reduce the disposition cycle. All laudable objectives, and of course, we have now seen in many, many jurisdictions the byproduct of these civil procedure rules which were introduced. I just want to encourage all of the stakeholders of the Bahamas, and most particularly the members of the bar, to fully engage in this process over the next 2 months. I'm very encouraged with the turnout today. The Bahamas Judicial Education Institute, which is chaired by Justice Winder, and I act as the president of that institute, have put together a training program involving 12 training sessions between the 2nd of March and the 4th of May. That's, what is it? 2 March, April, May, about 3 months. Throughout these 12 sessions, most of which will be virtual, but some of which will be hybrid. The president of the bar has offered us the use of the bar's office to conduct 1 or 2 of our hybrid sessions. We in the judiciary have recently opened a training center in Charlotte House, which we will also be using for some of our sessions. And throughout the full program, you will be taken through all 73 parts of the new CPR. We will be doing them in groups. Our colleagues from CAJO, the Caribbean Association of Judicial Officers, will be taking and leading 6 of those sessions. And we will have local presenters and practitioners leading the other 6 sessions, which will be done here in the Bahamas. As you all know, this has been a long time in coming. Several of my predecessors have worked on the CPR, but we finally were able to circulate the drafts, and I'm sure you've all received it. It is important that practitioners take the time to review them. You would have seen from the notice which I sent out that my intention is to ask the Rules Committee to promulgate the new civil procedure rules on the 16th of May, 2022. That is a hard date. We must do it. I'm reminded of that saying that the pursuit of perfection creates paralysis. And I think if we wait for it to be perfect, we will never do it. So we're on a track. We've done our homework. We've got 12 sessions planned. We're going to consult the bar. We're going to engage the stakeholders. We're very fortunate to have distinguished and experienced jurists from the Caribbean who've gone through this process several times in different jurisdictions. So we have set the table for the rollout. And I would encourage all members of the bar to stay with the program, try to attend as many of these sessions as possible. Your input will certainly be received. And so when we promulgate the rules and bring them into effect, you will be prepared both individually and as firms, as law firms, to migrate and transition to the new regime that will govern our civil procedure going forward. Now, with those few words, I welcome you. I am going to invite the president of the bar, Mr. Khalil Parker, to share a few words from him at this time. Mr. Parker.
Thank you, Chief Justice, and to my very learned colleagues, to Dennis, President Saunders, and Justice Jamina. thank you for sharing your time and expertise with us. And CJ, you've hit the nail on the head. The members of the Bar Association have been primed before. We have been ready before, and we are ready again. I am not surprised by the turnout today. We will engage with this process, and I encourage members to participate fully and to let us know your thoughts and offer any insights you have as we go through this exercise. I think we're all ready to hear from the panel, so I won't take up any more of your time. Thank you, and we look forward to working with you on this project. Well, continuing to work with you because this is the public-facing version. We've been working on this for quite a while, and it enjoys Bar Council's full support.
Thank you, Mr. President. That is, of course, very important because there is no way, and I'm sure this point will be made by our presenters, there is no way that we have any prospect of success in this project unless we have the full cooperation of the bar and the full buy-in by the bar for what we are doing. So it's good to hear that, Mr. President, and I look forward to the continued cooperation and support of Bar Council and members of the bar as well. So I'm now going to turn it over to our panelists. I don't know whether President Saunders or Sir Dennis will start off, but let me ask you now to take over the session. We look forward to your presentation. Just a few protocols. Please, as I think most of you have now done, please keep your microphones muted unless you are speaking. I'm not sure, and our presenters will let us know, whether they wish to hold questions and comments until they take a break or whether they want persons to indicate through either raising your electronic hand. You know, there's a feature that allows you to raise your hand if you wish to ask a question or make a comment, or whether we'll save them until the end of the session. I'll leave that to our presenters to indicate what their preference is. But otherwise, Mr. President, Sir Dennis, Mr. Justice Jamadar, over to you.
Yes, thank you so much, Chief Justice. And on behalf of our team, Sir Dennis and Justice Jamadar, I have to say that we are very pleased with this excellent turnout. Having both the bar and the judiciary being trained together, which is what Sir Dennis did when we embarked on this process back in 1999 in the Eastern Caribbean, affords possibilities, great possibilities, because everybody can be on the same page at the same time. However, it does not allow for us to perhaps present some nuances and emphases that one might have presented if you were dealing only with judges or only with the bar, but nevertheless, we can get around that. The manner in which we will proceed is that we will present in a very conversational manner, a conversation among Sir Dennis, myself, and Peter will chip in from time to time. And in the course of it's a PowerPoint presentation, we have several markers for entertaining comments, questions. But if there is something pressing before we get to those points and you want to interject or to make a comment, ask a question, then please use the raise hand feature. So yeah, Sir Dennis.
Well, thank you very much. It's a real pleasure to share this exercise in the Bahamas. I pick up on I pick up on a comment made by Chief Justice Brian, and I take the opportunity to congratulate you, Adrian, on the Caribbean Court of Justice being inducted into the International Framework for Court Excellence. It's a tremendous achievement. And as it reminded me of Sir Brian's comment, because you see, excellence is not a state that courts reach. It is the constant process of improvement, trying to get better all the time. So one does not have to be perfect to start. You keep on improving. And in that context, I think it's very important that the decision to start is implemented. One needs to start and learn the rules through experience and assessment. I noted that there's already a standing committee, a standing rules committee, and that is something which I think is very important. The rules committee should not be a temporary thing, it should be something that's permanent. It should constantly monitor the way in which the rules are being operating. And I hope that they might be in a position to report to the Chief Justice at least twice per year, with a view to ensuring that the rules are the best as that they can be, as they are honed by your experience in trying to work them out. So those will be my opening comments.
All right, Peter, you want to say a few words before we launch into the PowerPoint? Now, Peter and we call each other by first. Well, I will always call Sir Dennis Chief, because he is the Chief Justice who appointed me as a judge. But I ask you all to call me Adrian. We're among colleagues and friends here. Peter was not exactly scheduled to be here with us, but knowing him as well as we do, he made every effort, notwithstanding the fact that he traveled to be here. So he will also be very much involved in this session. Peter?
Yeah, no, thank you very much, President. So Brian, I want to congratulate you on your steadfastness about making sure that these rules are brought into force under your watch. I think the experience of the Caribbean is a common experience. Sir Dennis and the President attest to that, and so can I in the Trinidad and Tobago context, and that is, prior to the introduction of the civil proceeding rules, civil justice was plagued by endemic delays for many reasons, but one significant factor was systemic, i.e. the rules that were in place did not facilitate what Sir Dennis and the President will talk about momentarily, the kind of cultural change and empowerment of judges to work with the bar. And I underline that. When we come to the overriding objective, we will see that all parties, the bar must work with the judiciary to achieve what the CPR promises. But what I can attest to is that throughout the Caribbean, where the CPR has been enforced and it has been applied as it should, things have improved. There are places where it is enforced, and you will hear more about that in a little while, and it has not been applied as it should, and things have not changed as we would have liked. So I just want to say congratulations to you, Sir Brian. I also want to say congratulations to the bar and to everyone here, because I know that together we can make a significant difference for the people of Bahamas in the context of civil justice through these new rules. Thank you very much, President.
Sure. All right.
Adrian, would you permit me just to make an inquiry of Sir Brian?
Sure.
Have the draft rules been circulated as yet? Have the members of the bar and the judges have a chance to look at the draft rules?
Well, so Dennis, that's two questions. The answer to the first question is yes. The draft CPR, which I sent to you and to President Saunders and to Mr. Justice Jamadar, have been circulated to all of our stakeholders. But I think about a week ago, or maybe eight or 9 days ago. So I'm not sure that they've all had a chance to look at them too carefully. but they do have them.
Thank you. Thank you very much.
Okay.
And
Yeah, okay.
just while I am speaking, Mr. Dennis, allow me to make this point. I think the session will flow a little better if you can put your comments and questions in the chat room. And I will monitor that together with Mrs. Neely, and we'll make sure the appropriate time to address those questions and give you a chance to perhaps make some comments at the very end. Thank you very much.
Thank you.
Okay, all right, thank you. We should have mentioned that we are being assisted by Ms. Larissa Pena, one of our judicial counsel at the CCJ. She is going to be working the slides for us, and she has been very helpful in the preparation of this session. So you can go to the next slide, Larissa. Okay, so this sets out the objectives that we wish to accomplish this evening. We hope to be able to provide you with an overview of the new rules, focusing on the cultural and paradigm shifts which are required to successfully navigate the new CPR. And secondly, to expose you to the philosophy underlying the new rules and the fundamental changes that must take place if the rules are to take place, if the rules are to take root and to achieve their purpose. So that's basic objectives of the session this afternoon.
I suppose that the starting point has to be the overriding objective, because deep appreciation of what it means really encapsulates, in a nutshell, the entire cultural change that needs to be taking place. Because first of all, I don't know if any of you have your rules before you, but if you look at part 1, I'm not going to read it through, but it would be useful if you just had a glance at it. And you'll see that what is clear is that the overriding objective is to enable the court to deal with cases justly, which is a very lofty idea. And this implies, as far as I can understand it, a change from the adversarial approach to litigation, so that the judiciary, as well as the litigants, have to be motivated to try to achieve a fair and just disposition of the cases. And this is specifically stated out in part 1, rule 1.02 of the rules, which states that the duty of the parties and their terms of law to help the court further the overriding objective. And I think that as we go through with it, it's very important to keep the principles of the overriding objective before us as we go through and interpret the various rule changes that have been made. Thank you.
Okay, and all that fits into the theme that you see there, transforming legal culture. In fact, it might be said that the new rules carry us from one paradigm to another. And the essence of what these rules usher in is a different court culture, a different culture in the way in which cases are received, managed, and disposed. If that culture is not embraced, the new rules mean nothing. You could go to the next slide, Larissa. Earlier, we spoke of what we are moving away from. Well, we are not sure what the stats are in the Bahamas, but in some countries, before there were new rules, you had all the evils of the old system. tremendous backlogs. You had a culture of lawyer-driven litigation where the court simply reacted to what the parties did. The court was a passive, neutral umpire and waited on the parties to do something and reacted to that. You had a situation where on the morning of a trial, lawyers who had studied their cases the night before recognized that, well, this case can be settled. So, my lord, can we get a 15-minute adjournment because we can settle this case? And so you have a whole waste of time and resources because 2 days might have been put down for the trial. The judge would have blocked off a calendar for those 2 days. Everything would have been mobilized for 2 days. And in half an hour, the case has been settled. So you had all of these different problems in the civil justice system as part of a culture. The new rules attempt to move away from that culture. And what's on the screen is very apt. Culture, and this is something which Peter Drucker, who is a management consultant, is famous for saying, and it's an adage that is applied to the boardroom, to the corporate world, but it applies also to any institution. Culture eats strategy, eats policies, eats plans, and it will eat these rules for breakfast, lunch, and dinner. You can have the new rules without the culture. We know a judiciary in the region that has had the rules for a very, very long time. And the rules have not made the kind of difference they should, because there has not been the cultural change that is so necessary in order to make the rules work. And so we are going to spend a lot of time talking about how this new culture should be fleshed out. Next slide. So Dennis?
Well, I was going to make a supportive comment because as we go through our session today, we are going to be addressing the concept of the attitudes, the approaches that the bench and the bar need to adopt to make the rules work, rather than going through the rules, telling you what the rules actually say, because we think that you could read them yourself. But the critical point is that no matter how you look at the rules, the literal interpretation is less important than the approach that you take to the implementation. And it's, as Adrian said earlier, the fact that so many of the bar is present is a very encouraging sign. Because if the bar and the judges and the court office work together, that's the key for successful implementation of the rules.
Next slide, Larissa.
President, before you move on,
Yeah.
could I just make one little comment on the last slide, if
Sure.
you don't know me?
Yeah, you want to go back, Larissa?
So that on this slide, we talk about systems, discipline, and leadership. And one of the things that I just want to add to what both Sir Dennis and the President have said is that consistency and leadership, it's not for the court office, it's not for the attorneys, it's very much for judges to lead. And this is one of the big cultural changes that we will talk about throughout this, this session and other sessions. There is who has the main responsibility for transforming the legal culture? Who has the burden of leadership? And how do we effect cultural change? I think judges have to accept that responsibility, as does the court office, and of course attorneys. So we're all leaders, but the buck stops with the judicial officer. One of the things about changing cultures that we have discovered is that it's not enough for one judge to be doing it and 3 not to be doing it. There must be a consistent approach by all leadership across the board and over time. And those aspects are critical if you want to have genuine transformation. That's what I wanted to add, President.
Sure. Okay.
Adrian, could I make just a light-hearted comment? It's really an explanatory note to what Peter said. Once upon a time, the case belonged to the attorneys. But we think that what these new rules do, is that we make the case belong to the court. So I used to say, in a light-hearted way, that if somebody makes a mistake to file a case, that case belongs to the judge. And it is the judges who has the duty to ensure the way it proceeds through the system from beginning to end. So the judges now have to assume a responsibility for the way in which the case load proceeds. It's no longer the fault of the lawyer, it's no longer the fault of the court office. The judge has to make sure that what has to be done is done, so the case proceeds in a timely manner and produces a fair result, a fair and just result.
So that is one of the big cultural changes that is absolutely necessary to be embraced. Judge-driven litigation and not lawyer-driven. The responsibility rests with the judge to ensure that the case is managed and disposed of in keeping with the overriding objective.
President, that responsibility is vested in a constitutional provision. The constitutional the imperative for a fair trial, which includes timeliness, so that this is not something that the rules are introducing. The rules are actually giving effect to what is a constitutional imperative. And if you have a code of conduct, and if you don't, the Bangalore principles talk about similar approaches. So these new rules are ushering in something that is consistent with your core constitutional values. President, I mean, this is an area you're really competent at. Maybe you could add it. I know that we want to keep moving, but I think it's so important that we understand it's not just about rules, it's about much more fundamental principles as we move into the particulars that the next slide will invite us into.
Yes. Yeah. Well, there's very little to add to that, except to say that, to emphasize the importance of judges taking responsibility for the cases that are filed. The next slide is a placeholder for questions, comments, any thoughts, any questions? Anyone wishes to make any comment? If there is anything in the chat, I wouldn't be able to see it. I'm not seeing it. Let me see.
No,
no, not as yet. Okay.
Not yet.
Okay. Okay. All right. So we could go to the next slide, Larissa. Okay. So these are various facets of the manner in which legal culture is to be transformed. Yes, Tanya? You're on mute.
Yes, good afternoon. I was just wondering, your presentation began with a very heavy focus on what appeared to be a criticism of lawyer-driven litigation and the court being reactive. But is there any other way to move the court? And will these rules, is it to be expected that the rules will provide some other way to move the court, otherwise than a lawyer bringing the matter to court?
Might I, Stephen, I'm sorry that you seem to think that we are criticizing the lawyers. That's not the point at all. What is the issue is changing the system of how the matter used to operate. When I started practicing, the idea was that nothing would happen in the court unless a lawyer made an application. So if a matter if there was a default in entering a defense, or there was a case management process for 2 years, the case would just become a statistic on the court record. We think that as I think, I'm very happy that Peter mentioned the constitutional right of citizens. We think that denies the citizen their constitutional right to have a fair trial and reasonable time. So then once the matter is in the court, it's the duty of the court to ensure that the processes move from beginning to judgment within the time and in the manner set out by the rules. So it's not criticizing the lawyers so much as trying to address the culture that the court now has a responsibility to make certain that the case proceeds as the rules have set out that they should.
Yeah, so that, persons who have disputes, they go to lawyers, and the lawyers file the cases. But it is the responsibility of the court and the judges to ensure that once the case is filed, it moves through the system at a pace in keeping with the rules, not at a pace in keeping with what the lawyers would like, at a pace that the rules require. And so the court has to oversee the management of the cases in an orderly, proper manner. That is what we mean by judge-driven litigation. Lawyer-driven litigation is where the case proceeds at the pace of the lawyers, and the court waits on an application to be made to respond to the application, so that it is possible for a case to be lying dormant because one or both lawyers take no positive step to move the case forward, and the court simply sits back for that step to be taken. That is what we refer to as lawyer-driven litigation. Judge-driven litigation is where the court becomes a proactive manager of the cases after they have been filed, to ensure that they move through the systems in an orderly manner.
Adrian, may I give an example?
Yeah.
May I give an example, Adrian?
Sure.
We have been asked to assist another Caribbean jurisdiction in improving the effectiveness of the case management systems, and that's a court which has a very well-defined and active statistical department. And one of the facts is that there are 12,000 cases in backlog, of which 6,000 have a status of being inactive, because nobody, no lawyer or no litigant, has made any application for over 3 years in these matters. And it's still on the court record, and the court has done nothing. Now, what we are saying, that these rules ought to make that impossible to occur. Because if the rules require a step to be taken within a specified time, and the step is not taken by the attorney, then the court must initiate the taking of that step. So that's how that's the culture change that we are suggesting.
So Dennis and President, I think there's another question. But before that, we talk about not being lawyer driven, but we want to include litigants also, because it's not just the lawyers who may not be taking steps. Litigants can file a case for strategic reasons, for all kinds of different reasons. And the litigants aren't interested in moving the case. But as Sir Dennis says, and he put it very diplomatically, my sources tell me that when you walked into his court when he was a CPR judge, the first thing he told everybody in his booming voice was, well, you filed your case, but it's now my case. And he wasn't speaking to the lawyers only, he was speaking to the litigants also. And under the rules, you will see litigants must turn up in court. Not enough for lawyers to turn up. So when we talk about judge-driven, not lawyer-driven, read not lawyer to mean not lawyer or litigant-driven. I think that's something. So this is not about blaming anybody. It is about shifting the focus on who has responsibility.
Okay, Shavanya.
Sorry, if I may interpose, please, Adrian. I think we're going to get into some time difficulties if we have too many interventions. So I think the better approach here, because we want you to get through your material, is if you can press on with your material, and those that have questions, we will take a break at whatever point you think is appropriate. I will take some questions and then we'll get back to your text. Otherwise,
okay,
all questions are very important. I apprehend that we'll run out of time.
Okay,
I want
okay.
to make sure and get through your material, and then we'll take the questions at the appropriate time. Thank you very much.
Okay, all right. So, okay, there's a list of various aspects of how the new culture is manifested on the screen. We've spoken a lot about case management, about effective case management in the sense of the judge having responsibility for moving the case along, about the judge being proactive in doing so, the judge having that responsibility for ensuring that the case moves along. We want to talk now about the concept of treating each case as a project. Chief, you want to say something on that?
Yes. Thank you very much, Adrian. One of the points to make on this is that case management is not an individual activity, it's a team sport. Because if you look at the overriding objective, you'll notice that one of the criteria for dealing just with cases is to allot an appropriate share of the court's resources to each case. So it means that you have to know how the caseload as a whole is operating and organize your caseload in that manner. Now, the case as a project concept has to do with the issue of judicial management. And we came up with this idea because we thought that under the new culture, the judge actually becomes a manager. Because what he's now doing is trying to make certain that the way we do our work is better. And the most effective operators are successful businessmen and who operate on the business of the case management business. Now, Larissa, could you put up the little screen for the little slideshow that we have? So what we imply by this is breaking down the process of the case into milestones. And I take, for example, what we put up on the screen is a very simple case. And you see the case is filed. Now there's no obligation as to, in the rules, as to when the case must be served. But we know that if it is not served within 6 months, it can be removed from the court list. But once it is served, then time starts to run. So we have here milestone number 1, the date on which the case is filed by the claimant. The second milestone, which is set out in the rules, Rule 9.31 is that an acknowledgement of service must be filed within 14 days. So if we allocate 14 days for the second milestone to occur, we have a date there for that. The third milestone in the rules is the filing of the defense, which must be done 28 days after the matter is served. Now, you have other proceedings which could take place, but in a simple case, the next milestone is the reply, which the claimant can do. And Rule 10.91 states that the reply must be filed within 14 days of the defense. Milestone number 5 is the case management conference. And Rule 27.33 states that the case management conference must take place not more than 12 weeks after the filing of the defense. And so we have here on this date, 12 weeks after the defense has been filed. And then the fixing of a trial date. Rule 27.4b states that one of the duties of the case management conference is to fix a trial date. Now, of course, there are other things that might happen, pre-trial reviews and that sort of stuff. But the rule 27.92 states that the trial should take place not less than 8 weeks after the case management conference. Now, here you have the rules themselves setting out a performance standard for the conduct of litigation. And what this implies, to my way of thinking, that in every case, I suppose there must be exceptions, and the point I make about that this is not the only case on the court file, so there has to be a sharing of resources. But a simple case, should reach case management conference in 112 days after it has been served. And I think that there should be an effort to ensure compliance with that. Now, if you notice that if the case proceeded according to the rules, trial would take place 168 days after service. And as we have been saying from time to time, that this would make it a simple case, so judgment should be delivered on the same day. So I don't know, Adrian, have I said enough on this matter?
So that is an example of how a case can be projectized. There are other ways in which you as a lawyer or a judge can also projectize a case, because under these rules, it is important that the work is front-loaded. That is to say, you devote maximum attention to the case at the outset. From the lawyer standpoint, when you receive your instructions from the client, you haven't even filed as yet. You begin to map how you see this case unfolding. Is this a case that is one that is ripe for mediation? Is this a case which is going to involve complex facts? Is this a case where the facts are simple, but the law is complex, and therefore you need to do a particular amount of research and so on, so that by the time you file your case, you can begin to think of a plan for how you see the case unfolding? from the standpoint of the judge, after the case is filed, you look at the statement of claim, a defense is filed, you look at that defense, and I think later on we talk a little bit about narrowing issues and how we approach case management conference. But a lot of work is done at the beginning part of the case so that you can get a good sense of how you can projectize this case. Is this a case that should go to arbitration, for example? You know, or is this a case that you could send to mediation? Or is this a case where the issues are so difficult that you are going to need several case management conferences? The point is that each case is different, and you need to plan for each case as it is filed. Can you go back to the screen?
President, can I just add a comment on that, a very short comment? Just because I think this is such a critical point about projectizing. And I think there are two things I really want to say very quickly. One is, imagine you want to build a building and the architect or the builder builds something and then says, let's do this and do that. How long will it take? They don't tell you. They just do in the basement and then doing this and it's just going along like that. Well, you're not going to be happy. The litigant is not happy. The system is not happy. The law, nobody is happy. Projectizing brings focus. It brings structure. It brings predictability. And at the heart of projectizing is the CMC, the Case Management Conference. What I want to say about the Case Management Conference that we'll come to a little further on maybe is it's also collaborative. The judge is going to sit down together with the litigants and the lawyers and lead, but try to agree on the plan, the project plan for this, I'm going to say house, but for this case, to get it to completion. And the truth of the matter is that's what litigants really want. They want to know, and you want to know if somebody's building your house. In 6 months, I'm going to have a house. You don't want to start building a house and you don't know it's going to take 3 months, 6 months, 5 years. That never leads to trust and confidence. And so that's why this idea of each case as a project is so central to the cultural shift we're talking about.
Peter, on that point, I should make a comment. The project that I had done had to do with a case which was the claimant had sued for debt, money borrowed which had not been repaid, and the defendant denied that it was a debt and said it was a gift. So the issue of settlement had been issued, and it was a simple matter of determining which one was telling the truth. So in a simple case like that, this is a possible project document that one could set out. As has been described, if the case is more complex, well, the project document is different. And as Adrian said, that you deal with the matter at the beginning by reading what the claim is about. And that is when you know what type of project you're going to have to deal with.
Just providing a time check.
Okay.
Thank you.
So we need to get along. Performance standards. Chief, you want to say something quick about that? The importance of setting performance standards.
Yeah, well, I must say, this is a matter which I have become a little bit of a missionary about, because I actually feel that the secret of successfully applying the rules is really accepting the concept of measurable performance standards for the way we work. So if the court office, the judges, the lawyers, accept that the time from filing to disposition must fit certain standards which the court or the court and the lawyers together may set. That's critically important. And if it becomes important to know, is the court disposing of as many cases as is filed in the calendar year? How old are the cases on the court record? Do you have any cases that have been on the record for more than 5 years? What percentage of the cases are there? Now, these are issues which you need analysis, you need statistical analysis, and you must have standards to say that we are going to aim to address our time to disposition in this manner. Now, once you accept the concept of performance measurement, you can measure many other forms of activity. How often, and how many cases is a case management conference heard within the time prescribed by the rules? Is it, so one can say that it's now a performance standard in the court that there must be a case management conference in 90% of the cases 12 weeks after the offense. And that is a standard that the bar and the bench can aim at. So you could have other standards, for example. If a case is disposed of in less than 1 day, you could have a standard that in 90% of the cases, the judgment should be delivered on the same day, for example. So one can, I'm not saying that is what the standard should be, but I'm saying that that the stakeholders must get together and identify the measurable performance standards which the system is going to aim at. And I use the word system because, as I said earlier, this really is a team sport and requires participation, understanding of the key stakeholders.
At the CCJ, for example, the way in which we approach this issue of performance standards, you have criteria for dividing the cases into simple, average, and complex cases. And we have our own internal time standards for how long from filing to disposition a simple case should take. How long should an average case take? How long should a complex case take? And you have the same kinds of performance standards in relation to judgment delivery, for example. Simple cases, judgment should be delivered within a month. Average cases within 3 months. Complex cases within 6 months. And you, over time periods, whether a year or half year or whatever, you look to see how well you are doing in keeping to those performance standards. Because it is when you have these measures and when you evaluate whether you are keeping to these measures, it is only then that you are able to challenge yourself to see whether you are keeping within what you have set yourself or whether you are lapsing and therefore need to direct more resources or better resources to the ways in which you have lapsed, or whether you are keeping in tune with the standard and you could make the measure even a little bit more aggressive. So setting performance standards is one way of the court aiming to enhance its efficiency. Outcomes really matter, timelines and timeliness. Well, we've spoken a little bit about the importance of timeliness. Proportionality, the overriding objective. It speaks about ensuring that we allot to each case an appropriate share of the court's resources while taking into account the need to allot resources to other cases. So that if there's a case which is relatively simple, then we ought not to expend a lot of the court's resources, more than is proportionate for that kind of case, to dealing with that case, because there are other cases in the queue. And while each person deserves a hearing and each person must get a hearing, nevertheless, we have to be conscious of the fact that we must be allocating an appropriate, and the rule says so, an appropriate share of the court's resources to each case, taking into account the need to allot resources to other cases. Judgment delivery, Peter, you want to say something on this?
Yeah, sure. I think, I mean, just short because we want to move on, but a case is not finished until a judgment is delivered. So when we talk about the new system is from filing to disposition. Disposition does not have to be with a judgment. It could be by ADR, but once you reach a hearing, the responsibility of the system and of the judicial officer is to deliver a judgment in a timely fashion. So Dennis spoke about simple cases. There's no reason why simple cases, he spoke said a day, but I would say that within 1 or 2 weeks, certainly nothing over a month. Average cases, we've shared the CCJ standard, but it's for you to work it out. But part of the project should be judgment delivery. And a practice we commend to you all is this. At the end of a case, judicial officers should say, I will deliver this judgment and set a day and time, whether it is a week, a month, 3 months, whatever it is. Why? It puts certainty to the system. Litigants want to know when. Can you imagine you're a litigant and you're waiting and you heard anything? No, that's not even fair. A fair hearing means the litigant must, at the end of a case, in an ideal world, be told, within 3 months, you'll get your decision. And that puts a responsibility on the judicial officers and on the system to deliver the judgment within that time.
Okay. Chief, anything else you want to say on this slide?
Well, an opportunity to say something to allay the feeling that we're criticizing attorneys. Timeliness and timelines are essential. You know, very often we hear, at least when we're doing judge-only training, for example, one of the major issues is analyzing the reason for delays. And we're often told that the lawyers are always asking for adjournments. And we have taken the position that the court, it's not open to the court to blame the lawyers because the lawyers don't grant adjournments. They just ask for it. So if the court grants the adjournment, how can you blame anybody but yourself? So we are saying that this is another point where the culture has to change. The judge has to know that the word adjournment is anathema, and the attorneys have to know that too. And again, that's the comment I wanted to make.
Mm-hmm. Okay, Larissa, how are we doing with time on this slide?
We should move on.
Okay.
I think we've taken up the time.
Okay. Okay. So next slide. This was a placeholder for questions, but I haven't seen any in the chat, so we could move along.
There is 1 or 2, but I think we need to move along and catch them at the end.
Oh, okay.
Because you're running a little behind.
Okay. All right. So we talked about this a little bit, front-end loading. Front-end loading, as I said a little while ago, is that you devote a lot of your reading time, your time with the case at the beginning, not at the end. This again is another big culture change. In the past, what happened was that we file a case and you have a little bit of give the case a little bit of attention there, and the other side gets it, has to file a defense, give it a little bit of attention there, and then we don't do much about the case until you get a trial date. And then on the day, 2 nights before the trial, you begin reading the file, whether judge or lawyer, in preparation for the trial. Can't do that under these rules. Under these rules, you devote a lot of the time to dealing with the case at the front, because at case management, which takes place 4 to 12 weeks, I think it is, after the defense is filed, the lawyer and the judge both need to know that case inside out, or otherwise case management will not be effective. At case management, both the lawyers and the judge need to know that case inside out so that they would be able to assess whether how you can narrow the issues in the case, which is the second point. Whether in fact there is a discrete issue which can be lobbed off from the rest of the case and tried as a separate issue. Sometimes in the defense, somebody might raise a point which is a knockout blow that does not depend on evidence. It only turns on law. Well, why are you going down to have a hearing on evidence when you can segregate that particular issue and deal with it? And if it succeeds, that's the end of the case. If it doesn't succeed, well, you wouldn't have lost anything because the case goes on to trial, but that issue has already been resolved. So front-end loading is critical. It is critical to narrow issues. It is critical to deal with what the rules say, the overriding objective. Chief?
Well, I think you hit the nail on the head, because one of the major issues at the case management conference is narrowing the issues. And as you've rightly said, sometimes there is a percentage of cases where there is an issue which, if resolved, will determine the case. And if that is identified and that issue is adjudicated upon, then all of the overriding objective principles would have taken place, and the case could probably resolve quite quickly. And that's an issue which requires preparation. And we're going to discuss this in some detail at one of the other sessions. So I probably will not say any more at this time.
There's something, I'm not sure whether we address specifically the case management responsibilities of the judge, but there's something I want to say here. If it comes up again, we'll deal with it. And that is that under these rules at case management, it is not only the lawyers who are to appear before the judge. The rules require that the litigant also appears. And that is critical because it assists in the exploration and encouragement of settlement. It assists in having the litigant fully understand and appreciate what is going on with her case. In the past, the litigant goes to a lawyer, makes a complaint, gives a statement, whatever, and then is alienated from the case. Under the new rules, that is not encouraged. It is important that the litigants are interfacing with the court at the case management conferences so that they are aware of the orders firsthand that the judge is making, so that they are aware of their cost exposure, which is something that we could get onto, so that the possibilities for encouraging settlement are increased, because with their more intimate understanding of the case, each side, there is now a better platform on which to explore and encourage settlement. The only other thing on this slide.
President, can I just make a little comment? Can I make a very short comment on settlement? The language of the rules is imperative. the court, when you read the language of the rules around encouraging settlement, the language, it repeats itself in several areas, but there's an imperative on the court and the system to encourage settlement. And there is a duty, a corresponding duty, the rules say this, on the attorneys and litigants to support settlement. And so I think there is something that we need to understand. The CPR succeeds if most of the cases are disposed of without the need for a trial. One of the cultural changes was, the old model was, a case is prepared for a trial and you get a trial and a disposition. The new model is this: as little cases as possible should end up at a trial. As many cases as possible should be resolved or disposed of without a trial. And therefore, settlement is a key to achieving what the new rules envision for the just disposition of cases.
Chief, you want to say something on pre-action protocol?
Yes, well, a small comment. The next item, maximize early disclosure, also plays in to what both yourself and Peter spoke about, because early disclosure also facilitates more knowledge about the factual issues, which could help to narrow the issues or perhaps assist in reaching an early settlement. So the point about early disclosure is also fundamental to the successful operation of the CPR rules.
Okay. When you have in bracket a pre-action protocol, I didn't see any pre-action protocol, any rule providing for that. In some jurisdictions, there are rules providing for pre-action steps that must be taken so that when you are briefed as a lawyer to file a case, even before you file, there are steps that you must take to reach out to the other side, to have them aware of the steps that you intend to take, the claim that you propose to make, all in an effort to reach early settlement if that is possible. But that we just put that there as something to think about. It doesn't appear as though in the rules there is provision made for pre-action protocols. Next slide, Larissa. Preparation. We don't want to intimidate, to frighten either the lawyers or the judges who are present about what has to be done to operate these rules in an efficient and proper way. But it is the case that the rules really require a certain degree of assiduousness on both parts, the lawyer, the bar, and the judge. The reward for that, of course, is that at the end of the year, you will know that you have addressed, you have dealt with, you have disposed of far more cases than you would have under the old rules. There's greater satisfaction in knowing that the justice system is earning a greater level of trust and confidence on the part of the public. But with everything, like everything else, you got to roll up your sleeves. Do the front end loading and do a lot of preparation. Skillful use of sanctions. Chief, you want to say something on that?
Yeah, well, just a couple of days ago, one of the senior counsel in Eastern Caribbean reminded me that when we are rolling out our rules, an issue came up about how was it going to affect the commercial life of the lawyers. This thought that we are sort of making them lose money, so to speak, was part of an issue that had to be discussed. And I made the point, he said, which I had forgotten about, but that how do you make more money? Do you make money having cases open for 3 or 4 years, or having cases disposed of within 6 months? And he told me that simple thought he attributed to a large part of the success and development and growth of his practice. So I think that the point, I think that there are rewards for the front-end loading that are many in all cases. Now, again, the use of sanctions. Now, again, that also makes some people nervous, but I don't think it should. One of the points that we have to understand and is that procedural justice is justice. I think that is Peter's phrase, which I'm borrowing Peter. but procedural justice. So if the rule says you must do something at a certain time and you don't do it, why shouldn't the court take action? Now, bearing in mind, as I go back to the overriding objective is to deal with cases justly. So the sanction is not just a draconian activity, but it is to make certain that the cases are dealt with justly. Now, the rules themselves set out a number of sanctions that can be applied, striking out cases, case forms, making orders for costs or for wasted costs, and that sort of stuff. But the purpose of it, and why we use the phrase skillful use, is that the skillful use of sanctions will support and encourage compliance with court orders and the rules of the court. One of the things that we often say to, we encourage, is that we feel that technology, we are very strong on the use of technology in support of the rules. And so we think that there should be case management software, which is supportive of the use of the rules. And one of the capabilities of it is to issue reminders to people who have duties to perform. You'll notice on the Excel spreadsheet, there was a column as to who had to do which duty on which date. Now, one could have a system where each person who has a duty to perform on a certain date gets a reminder. And that also takes away the sting of sanctions if people are reminded and then they have an opportunity for compliance within the stated time.
Now, under the rules, there are certain, a number of different events that take place. The date within which you must put in your defense, the date of the first case management conference, the time when you must have a pretrial review, and so on and so on. The rules categorize these events differently. You see the trial date, that is a critical date. So that when the court says the trial will take place on the 15th of March, you can't come on the 16th of February and says, well, you want to abort a trial date, or you want to do something that will cause that trial date to be avoided. The trial date certainty is one of the features of the new rules. You keep to the date of the trial. Similarly, the date on which the court sets down a case management conference, that also is an important date. So there are these dates, and as we go through the rules line by line and so on, you will see the regard that the rules place on these particular events, because depending on what the event is, you may face difficulties in seeking to upset that event in any way. The concept of adjournments sine die, that does not exist in the rules. There is no reason why any proceeding in a case should be adjourned sine die. It should always be adjourned, if it has to be adjourned at all, to a certain date. And there must be something that taking place between the time that it is adjourned and the date on which it is coming back before the court. The idea of a case just meandering through the system in a meaningless fashion, the rules don't support that. Every case has to be advanced with each event so that it goes from event to event towards final disposition in a linear fashion. Peter, does anything?
President, just to say that this is all part of what we mean when we talk about projectizing a case. The skillful use of sanction is to advance the case with every event to certain dates, no general adjournments. But what you can begin to see is the judge as manager working together with attorneys and litigants, planning a case, a project, and then taking the management decisions, which are orders and directions and sanctions, to ensure that this plan is executed. Plan the work and work the plan. Plan the work and work the plan. Step by step, step by step. It brings public trust and confidence. It brings economic returns. It brings effectiveness and efficiency. So this whole slide is a critical part of what we spoke about in the last slide about projectizing. These 4 bullets are concrete approaches to facilitate the efficient and effective projectizing of a case.
Adrian, can I make one addition to that?
Yeah,
because
sure.
it fits into Peter's last comment. Whenever we have looked into problems where there's been a long delay, and the court said where it takes a long time from filing to trial, we have noticed that it's not because the case has not come before judges from time to time. A common feature in delay is a proliferation of interlocutory proceedings before the judge. And one of the culture changes in the new rules is to try to minimize the number of interlocutory appearances in a case. So we would think that, or what we try to teach, or what we try to encourage, is that the first interlocutory hearing, which is a case manager conference, the judge and the lawyers and litigants, through preliminary interrogation of each other, would determine all of the matters that need to be addressed in order for the trial to come on fairly, and have them all dealt with as at an early single case management conference instead of several repetitive conferences. So we're thinking another way of achieving the overriding objective is to create a plan which will allow as many interlocutory matters as possible to be dealt with at one time.
Larissa, how are we doing with time?
We have about 1 minute for the questions.
Okay, let's go to the next slide. Okay, is that we could take a minute of comments, questions quickly?
There are a couple of questions in the chat. Will, and I think this, you may have addressed this in your last comments. Will case management conferences be the preferred venue for planning interlocutory matters as well, or should they be done before, as is currently the case?
No, well, so then it's just dealt with that. The case management conference is the forum for identifying or hearing case applications and for addressing them in an orderly manner. The idea is that at the case management conference, I think there's provision for a listing questionnaire to be sent out so that parties can indicate what applications they wish to make at the conference. And the judge can provide a process for having them indicate their evidence or their submissions on the application, and the other side to submit their responses to the application. And at the case management conference, you try and deal with as many of them as is possible. Of course, you have a discrete amount of time so that it may be necessary that you, if there are a lot of them, that you adjourn the hearing of some of them to another time, but at least you would have addressed as many as you can. But
can I just add a little comment to that? Every application does not have to have an oral hearing. So one of the case management tasks is to discover what are the applications, okay? Some of them can be disposed of by saying, you file, this is your application, file your written submissions, file a reply, and I will give a decision based on the papers. So one of the things that we tend to do in the old culture is move from oral hearing to oral hearing to oral hearing. There are not, I won't say all, but many interlocutory matters can be determined on the basis of written submissions.
okay, one last question.
One more question. These rules seem to be placing a lot of responsibility on the judge. Who or how will the judge be managed? Because there are times when the delay or the backlog results from the judge's delay in delivering the judgment.
Okay, well, this has to do with judgment delivery, performance standards in relation to judgment delivery. That's something which the judges have to arrange, that, as we said earlier, that we set ourselves judgment delivery performance standards and we adhere to it. If it is that the judges need training on delivering oral judgments or on writing judgments, then the judiciary has to try and arrange that training. But it is important that the judges also have performance standards in relation to the giving of judgments after hearing a case.
Just a follow-up question that's come in. Are there any consequences if a judge fails to meet a deadline to deliver a ruling?
Well, one of the unwelcome consequences is that Parliament gets involved, and nobody wants that. That has been the case in Belize, in Guyana, and
in Nigeria, President, for example.
We don't want, that is unwelcome. That is one branch of government getting involved in the internal affairs of another branch. It ought never to come to that. And so if the issue is training, then the judiciary has to organize training. If the issue is a question of the quality of judges who are appointed, then the appointing body has to look at that. But every self-respecting judiciary should have and apply performance standards in relation to judgment delivery.
President, can I just add one little question, one little comment on that, because two questions came about this. I think it is also the responsibility of the system to generate feedback information to the Chief Justice about, in other words, the Chief Justice should know every single judge and their list of outstanding matters from the date reserved until whenever. And those, when I was a High Court judge in Trinidad, I was a judge and a High Court judge for 10 years, a little more than that. And there were times when the Chief Justice at the time would call me up and say, Peter, I noticed you have 10 outstanding, 15 outstanding, what's happening? So a good mechanism to help with peer responsibility is a system that generates this information for the Chief Justice or the Chief Judge, however you organize your system, and that a relationship be established, a practice be established, where if a judge is falling behind, Chief Justice calls up the judge and has a conversation, so that internally you have a monitoring system and you never reach the stage that the President spoke about, where the legislature intervenes to control our affairs.
Okay, just this, I think, will just be a 1-minute answer. You mentioned litigants appearing in person. If the litigant is a company, will a representative of the company be required to attend?
Well, absolutely. If the company has its counsel, and at a case management conference, a representative of the company should be also present, in the same way as if a litigant, who is not a company, an ordinary individual, hires a lawyer, that individual also should be at the case management conference. And it should be a representative of the company who has decision-making powers, not a lowly representative, but perhaps a director, someone who is able to, because at the case management conference, a judge may require that decisions be made. And if the director can't be present, at least he should be present, should be a telephone away, so that his lawyer can contact him right away if there is a decision that has to be made that requires the directing mind of the company to be able to sign off on or to give a view on.
Hazrat, I think we should probably.
Press on. Okay. Yes.
I was going to say, I'll hold the others until the end, so let's press
Okay.
on.
Yes. Okay, so Dennis?
Well, I think that we have touched on most of these points already, because we have discussed the issue of that the fact that the case belongs to the judiciary, the buck stops with the judiciary. And I don't think it's something which the judges should feel fearful about. I think it's something which you should enjoy, feel empowered in, because basically the whole purpose of the purpose of the court is to perform in a manner which gets the trust and confidence of the public. And that is something, I think, which is very important in our societies, to have as a primary objective as we do our work. And this type of system that we're discussing helps to achieve that objective. Peter made a point about encouraging EDR. One of the interesting facts is that the courts with the best performance standards are the courts which have the least number of trials per year. So for example, just imagine what would happen in any court if you had to try 3,000 cases per year. You see, the encouraging ADR must be a high priority, and the judges must take every effort to try to facilitate and encourage settlements where possible.
So Brian, the issue of costs, discuss settle costs for inception. We have to be very diplomatic about this. But well, I suppose you have various degrees of subtlety and diplomacy. I have to tell you that I read the cost rules again and again, and I believe that those rules will not, as they are now, the jar with the general ethos of the rules, the cost provisions in a number of respects, because they perpetuate the old approach of bills of costs and having the taxation of costs as almost a mini case that goes through a very elaborate process, sometimes a Byzantine process, and which so turns off lawyers and litigants alike that not many taxations are done, with the result that a lot of successful litigants are never repaid. I suppose that's good for the losing litigant who gets off just having to pay their own lawyer. But a lot of successful litigants who should be repaid, some at least, of their fees, they are never repaid because everybody just gives up on the tedium of having to go through a cost regime that requires the kinds of processes and intricacies that we had in the old rules. So at some stage, we want to have a discussion with you about that particular provision. Maybe it's already cast in stone, but in many of the other jurisdictions, you are able to, at the case management conference, to say with the client there, this case, if you go to trial and you are unsuccessful, the likely cost that you will have to pay will be X amount, because there is a formula for being able to arrive at the cost. These rules, as I see it, apart from fixed costs, which are really for particular events, specified sums, and for particular things, they have provision for detailed assessment before the registrar, or for assessment by a judge after the case has been heard, as distinct from being able to determine what the costs are at the outset, even at the case management conference before the case is heard. The best time to be able to get parties to agree costs is before the case is heard, when neither side knows who is going to be forking out those costs. That's the best time to get agreement on costs. And so many of the rules capitalize on that by making provision for costs to be addressed in numbers before the case is heard and anyone knows who is going to be paying and who is going to be receiving costs. So that was something which I noticed with part 71, I think it is. But I don't know, Sir Dennis, if you wanted to add anything to that.
Well, not now. I just to say that I fully support the comments that you've made. And I would look for an opportunity to discuss it with Sir Brian. some of the thoughts that we have on this matter.
Yes, well, absolutely, we will do that. And of course, we'll get the views of the bar. But you're right to this extent. We deliberately at this stage did not include the provisions for budgeted costs or for projected costs, which are the regimes that I think you're referring to that other jurisdictions have. There is 71.9 that says the general rule is that there should be a summary assessment after the hearing or the application. So you are right to say that under the current draft, cost is really dealt with after the application or after the trial. I think under the current rules, taxations which don't exist anymore, they're called detailed assessments, they will be few and far between, because the rules make it very clear that I think it's 71.9, for those of you who may have your rules. It says that the general rule is that costs are to be assessed summarily, but you're right, it happens after the fact. But we can absolutely have that discussion, and I would value your views on it, and we'll get the input from the bar.
Yeah.
But we are right. Sorry, you are right in saying that the budgeted costs and the projected costs, and the fixing of costs up front of the CMC, those provisions were excluded. And I take your point that we should consider whether we want to do that or not. So I look forward to having that discussion with the three of you, and also get more on that.
Okay.
If I may just take 1 minute, I would encourage the bar to look carefully at parts 71 and 72. I mean, costs are always near and dear to the hearts of lawyers, even though these costs are not necessarily client attorney. So you want to look at 71 and 72 quite carefully, and you can compare that with the comparable rules in Barbados and the ECSC and Guyana. And I think you'll see the point that President Saunders has adverted to, and
CJ,
what do we need to discuss. Yes, President?
Okay.
yes, I wanted to ask President Saunders, I think you touched on it, if he would direct us to one or two jurisdictions he'd like us to look at in that regard.
Sure. Well, the Eastern Caribbean, I think Barbados as well.
Trinidad and Tobago as well has
Trinidad.
prescribed costs and budgeted costs, everything.
They're all the same. Barbados, Guyana,
Jamaica, all right,
Jamaica. They're very. I've looked at all of them. They're very similar.
Yeah. The key one is not even so much budgeted costs as much as prescribed costs.
Prescribed costs.
Yeah. Which is the cost standard that is most often applied. And it is one where there is a table that sets out how you calculate the costs. And the calculation is based on the value of the claim. So every claim is given a value. The value can be how much if it is a money claim, how much the suit is for. You sue somebody for $1 million. The value of the claim is at the outset $1 million. But if you sue someone for a judicial review proceeding or for something which does not have a notional value, there is a default sum, which is the value. Now, at the case management conference, it is possible for the judge, for the lawyers to say to the judge, the face value of the claim is $1 million, but given the complexity of this case, given a number of witnesses that will be called in this case, we would like the court to fix a value of the claim at $50 million so that the calculation would be on 50 million instead of $1 million. It doesn't mean that you're now suing for 50 million. All that it means is that if your suit is successful, that the cost will be calculated on 50 million. So there and then at the case management conference, everyone would know, if the judge agrees with that application, that the costs, if you are successful, will be costs on 50 million. And you do your calculation and you know how much that sum is. And the client who is there, both your client and the other side, would know, well, that is the cost I would receive if my side is successful, or that is my cost exposure if I lose. So that it is very, it has a lot of uses from that standpoint, because everybody knows from beforehand what their cost exposure is, what the cost they are going to receive is going to be. That's the prescribed costs system.
President, just taking a look at the time.
Okay, so we need to move on. Anything else you want to touch on here, Peter or Chief?
No, I just want to say the last bullet, respect, dignity, and equality. Very quickly, there's a lot of work on something called procedural justice, which basically says this. It says that when you treat litigants with respect, with dignity, and with equality, actually there is an increase in compliance in court orders, and there are increases in public trust and confidence. So one of the things we want to talk about when we talk about transforming the legal culture is judicial officers in particular must always bear in mind that it is not a lawyer's case, it is a litigant's case. And so we must always keep in mind that we are speaking, yes, to lawyers, but we are really speaking to litigants. So our language should be clear, our orders understandable, access to relevant information should be timely and accessible. And how we talk in court is important. Very, very important is, I'll tell you a very short story. One of the best judges we had in Trinidad in terms of, equality. And so we actually did a little experiment where we asked volunteer judges if we could come in and film them, record them in proceedings. And we recorded this judge. And when we showed it back to him, he was aghast. Why? It was a case of a self-represented litigant. And 90% of his body language was turned this way and speaking to the lawyer, And the self-represented litigant was there. He didn't turn to face the self-represented litigant. He very rarely addressed. And so that what happens in that situation is that the self-represented litigant or a litigant represented by a senior counsel, and you pay such deference on a junior counsel, you don't, that is not ideal. So when we talk about transforming legal cultures, we want to encourage you to become aware of who are our customers, litigants, and to become aware of how we conduct ourselves in court to show respect, dignity, and to treat parties with equality. I mean, you can do a whole education program on that, but we think it's important, this new cultural change, to include that element, this element, in the shift in cultures. Not to say that you all are not already that way, but to be aware of it.
Yeah, go ahead, Larissa. Okay.
Probably have time for one question, please, President.
Yeah, okay.
All right, let me get one out of the chat group. Will a judge's direct involvement in promoting a settlement not lead to the perception that the judge has a particular view of the respective merits of the claim or the defense, and therefore to the perception of a loss of impartiality in any judgment in the event that the matter is not settled, or will the judge try the action?
Right. You want to take that, Sir Dennis?
Let Peter do it.
Okay, Peter, you better take it.
Yeah, encouraging settlement does not necessitate giving an opinion as to whose case is better. So that's the first thing. The imperative to encourage settlement is a systemic thing. When you have full disclosure, and when you narrow issues, and when you identify and focus on what we call the main issue as opposed to peripheral issues, those systemic steps facilitate settlement, naturally so. We spoke about pre-action protocols. If you choose to introduce those where you must disclose information up front, pre-action protocols facilitate settlement. Disclosure facilitates settlement. So there are systemic aspects to promoting settlement, which a judge can proactively advance, i.e. disclosure, etc., that facilitates settlement. Of course, a judge should not give an opinion. If the judge is going to do the trial, the judge should not give an opinion and say, oh, well, I don't think your case stands a good chance. That's we'll say that's a no-brainer. There are some models that exist. There's something called judicial settlement conferencing, where if a judge thinks that a case can be settled, the judge can say to the parties, I'm doing this case, so I can't engage a certain process, but I'm going to, if you are willing, I can send you to another judge. That other judge who's not going to do the case listens and looks at the case and gives what is called a non-binding evaluative opinion as to probability of success or failure. And so what the other judge is going to say, look, I'm not doing your case, but if I had to do your case, this is what I think your chances are, and here's why. Judges are basically going to, you decide what you want to do. But of course, that's something you have to put in place. The third aspect about it is this: make use of ADR. The president spoke about arbitration. You need to have a mediation, a support mediation, I suppose, system to coexist with the new rules. And so Janice can talk more about that, how important mediation is. But encouraging settlement does not have to result in bias or the perception of bias for the reasons I've given and the technique I've spoken about getting another judge to give a non-binding evaluative opinion.
I think, Peter, isn't that now called early neutral evaluation? ENE?
Yes, it's the same thing.
Yeah.
Yeah.
That's actually written.
It's written into the
our
rules. Yes, I saw that.
Yeah.
Yes.
I've included that in our rules.
And so that is a technique which prevents, the questionnaire is asking, well, doesn't it mean that the judge is going to be perceived as biased? Using, I have the old language, so Brian, forgive me, but using that non-evaluative binding option circumvents that the problem that the questionnaire has asked. But what I really want to just come back to, and we don't have much time, I know, is by the use of the rules, the system in disclosure, etc., facilitate settlement. And I want to just add this little piece because the president and Sir Dennis spoke about it. Costs. When parties know upfront what the costs are, you will be surprised to see that there is a certain percentage of cases where that information facilitates settlement. I remember doing a case anecdotally, and when this was the old system, reached a court, they were fighting over a strip of land, 12 inches, 1 foot wide by 100 feet. So it was a longer boundary. And I asked a question, the parties were in court, I asked a question, has anybody discovered the value of that strip of land? They hadn't, because they were fighting a boundary dispute. I said, I'm putting this case off, I think it was for 2 or 3 days. Come back and give me the value of the land. They gave me the value of the land. I said, I want to speak to the attorneys. I said, the land value that you all are fighting over is X. How much have you paid your attorneys and what are you likely to pay? And also put into the equation, one of you is going to lose and have to pay costs. The lawyers said, can they get an opportunity to consider settlement? And the case was settled. Because the value of the dispute was not worth the costs. So even the question of the early identification and locking in of costs facilitates settlement.
Okay, next slide, Ursa. Okay, we've talked a lot about these issues, the importance of identifying and narrowing issues, of encouraging ADR, and we want to make the point again and again and again. And these rules differ from the old rules in the sense that the old rules almost presumed that every case that was filed was going to go to trial. And so the entire entirety of the rules was based on preparing for a trial. These rules have various areas where ADR is encouraged. In fact, it is written specifically. It's written specifically into the rules that ADR is to be encouraged. And it's just not possible to try every case that is filed. And therefore, we have to find ways of disposing of cases without a trial, through settlement, through early neutral evaluation, through arbitration, through mediation, and all of these different ways of ensuring that only those cases which cannot be disposed of by these various means are set down for trial, because you simply don't have enough courtrooms and enough judges to try every case. So Dennis, any thoughts?
I think that we have had a very interesting. We don't know what feedback we're going to get. We'd like to get some feedback, but I hope that we have succeeded in explaining that more importantly than the actual language within the rules is the approach adopted towards the implementation. And if both the judges and the bar buy into the idea behind the rules, then I think that's the 3/4 of the battle would have been won. Just the acceptance of the concepts that the new rules imply should be applied in the management of the civil procedure rules. But that's why we think that the title, Transforming Legal Culture, sums up what really is required to make these rules work effectively.
What's the next slide, Larissa?
The next slide is a question slide.
Oh, okay.
Yep.
Yes.
President,
So,
can I make a short comment on the third
Sure.
bullet?
Mhm.
I just think it's important. What is the performance? So Dennis spoke a lot about performance standards in the president. Conceptually, what is a performance standard in the management of a case from milestone to milestone, from event to event? We're moving along in a project. And we want to say very strongly that the conceptual performance standard, not 14 days, 15 days, no, concept is set the shortest reasonable timeline between an event. That's very, very important. So it's not about, oh, give me 6 weeks, because if you're not careful, it's going to be 2 years down the road. The judges have the primary responsibilities, but the litigants and the lawyers have a duty under the overriding objective part 1 to work with the court. What is the shortest reasonable timeline between events? And therefore, there must be zero tolerance for delays. The only way, when we talk about the new rules, there are 2 words that are like mantra words: efficiency, effectiveness. Once you start talking about these new rules and you bring in people to talk to you about them, efficiency of the system, the effectiveness. Efficiency and effectiveness turn a lot on zero tolerance for delays. That is not to be harsh. It is to develop a culture where when you say you are going to do something, it's going to be done within the times that have been agreed. And the last bullet is adjournments are anathema. We spoke about that. That is the great, great vice of the old system. And the new culture is adjournments are anathema.
okay. I just want to get back to the identification and narrowing of issues, because that is such a vital aspect of case management. And the responsibility of the judge in knowing the case inside out, as I said at the outset, certainly at the point of case management, is to be able to assess what are the discrete issues which are critical in this case. Very often you have pleadings that are, take up a lot of pages, but sometimes there are very succinct points which are determinative of the case. The judge must be able to identify these and to see how they can be addressed as early as possible, especially if they are dispositive of the entire case. Okay, so I think the next slide you said was...
Can I give an example of narrative issues?
Sure.
You recall the training session we are doing in another jurisdiction, where there was a claim where somebody had a fish farm downriver, and there was a manufacturing, I think it was a manufacturing plant, to be a manufacturing plant upriver. And the fish farmer claimed that effluent from that manufacturing farm had destroyed his farm, and they're suing for damages. And now the defense was like 30 or 40 pages, a lot of very, very sophisticated arguments to be raised. But at the training program, the case had went on, but so we picked this case, and we gave the participants the opportunity to try to experiment on the issue of narrative. And when we finished our exercises, everybody agreed that the case turned on one fact. What was the level of what was, you see, the river had been measured by people from the environmental office who had declared that the level of effluent was dangerous. And everyone agreed in the end that that was the critical fact, which, if determined, would have resolved the question of liability and litigation. And that is a matter which could have been dealt with very shortly, because it had to do with the credibility of the scientists that had been sent to measure the facility. So sometimes taking time to narrow the issues can have a really tremendous impact on the way in which the case is resolved.
So that the point is that in that case, a discerning judge, having read the pleadings, would simply say, this case can turn on the evidence of Mr. Jones, who is the scientist who claimed to have assessed the acidity in the water and so on. So let us set aside a day to take Mr. Jones's evidence on this issue. And just that proceeding could...
And if the other side wants, they can call witnesses to contradict Mr. Jones.
Exactly. You see?
Yeah, and the judge could make a decision.
So it's about being very discerning about, and to be able to be that discerning, you have to know the case. It's not enough to be a passive, neutral umpire waiting for a trial date when witnesses are going to parade before you. Unfortunately, or fortunately, because both Peter and I were trial judges when these new rules came in. So Dennis was a Chief Justice. And I enjoyed being a trial judge practicing these new rules. I absolutely enjoyed it because the case was in my hands. How that case proceeded, the time within which it was disposed, the manner in which it was disposed, all those things were in my hands. And so it, as Peter said earlier, it empowered you. It challenged you because you had to read the case, but you felt a sense of, what's the word I'm looking for? You certainly felt a great sense of achievement, seeing the cases on your docket being disposed of as time went on, because you are marshaling those cases along. The cases are not just meandering there in the system, just waiting. You are ensuring that those cases go from point A to point B to point C to point D until final disposition.
You see, in that case that we discussed, right? It was a real case which had been settled. But I think it was nearly 2 years it had been on the court file before it was set. Now, if at the first case management conference, which could have taken place 112 days after the matter had been filed, that analysis had been made. You see how soon the case could have been brought to a conclusion? And we think that is a key skill that needs to be developed in the conduct of case management conferences and the development of these new rules, because it is a skill which needs to be practiced and developed.
That's right. So that there will be a need for a more training programs for these techniques and these skills to be trained. But of course, the best way to learn these skills are to practice them, so that, you know, one has to keep practicing them. And I want to look at it now from the lawyer standpoint. If you were the claimant in that case, you charge your client a certain amount of money for the case or what have you. The point is that wouldn't you be better off if that case were resolved within 120 days than for that case to be open in your office for 2 years, 3 years? You're fighting up with the client throughout all that time. So it's a win-win situation. You know, the cases go through the system as quickly as they can. Okay, we're running out of time. Any questions?
A question in the chat box: are the costs of the front end loading recoverable in the taxation process since it occurs prior to the filing of the writ?
Well, sorry.
Before you address it, let me just refer the person who asked that question and others to part 71.5, subparagraph 5D. 71.5, 5D. The answer is yes, but President Saunders will elaborate.
No, well, I was just going to say that the rules don't make provision for pre-action protocols, so that at this point, one assumes that you're going to file a writ. And so once you file a writ, then the question is kind of odious, because then costs will naturally, be dependent on what occurs after the writ is filed. But as Chief Justice has said, Part 71 in any event makes provision for that. Yes, any other questions? I see something here about...
Just a process question. Will your PowerPoint presentation be on our website? We have to ask you whether you have a proprietary trademark in it, or you'll send it to me.
We can make that PowerPoint available to you. That's not a problem.
All right, but that'll be helpful, and we'll post it on our website, so it will be available. Thank you very much. Apart from introducing the CPR, are there any policies or practices which the judiciary needs to put in place internally to ensure that the required new approach to the management of cases operates consistently and uniformly across all civil courts?
Yes, well, let's challenge ourselves. Each of us will give you a different answer. Who wants to go first? Because the answer is yes.
Well,
I
understand.
Okay.
That's a very important question, and I think that just asking the question putting the question on the table is a very important development in this whole exercise. And as Adrian said, there are many different answers, some of which are not cumulative. I start off with the question of education. It's important that your Judicial Education Committee challenges the educational implications in a very strong manner. When we had our preliminary discussion, I had dropped the idea, it seemed to of a training program which went on every fortnight for a year, ensuring that the presenters, including the judges, the attorneys, and the principle that the best way of learning is to teach. So that my contribution to the discussion is the development of a strong program for judicial education, which is consistent and prolonged. Now, the interesting thing is that every generation of judges needs to go through this process again. So one has to sort of, I suppose, package education packages in such a manner that they can be reproduced when the judges come on board.
Absolutely. And that's what was done in the Eastern Caribbean. Yes, go ahead, Peter.
No, I endorse the educational aspect 100% plus. But insofar as the question is, insofar as the question is asking about policies or practices to put in place, my answer is absolutely. But what I want to say in addition to Sir Dennis is this. If there is going to be consistency and uniformity, not sameness, not the same thing, the court needs to have policies, internal policies, some of which may remain internal, some of which can be public, it depends, that speak to things like performance standards, for example, delivery of judgments, simple, standard, complex cases, timelines from filing to hearing dates to CMC. All of these are internal policies that need to be standardized. We always recommend a collaborative method with your judicial officers, for example, standardized and made known, at least internally. Now, the value of that is monitoring and evaluation. Not only, but there are several values. When you do it collaboratively, there's ownership. The cadre of judges who sit together and say, yes, we are going to complete a case with a simple case within X time. You own it because you are collaborated, you're part of it, good. But then it creates a standard, an objective standard for the evaluation of performance, monitoring and evaluation, which leads to feedback into the system to say, well, look, we're kind of going off track now. Simple cases, we said 6 months, but they're now taking 8, 9, a month, whatever it is. So what I will add to the conversation is the need for the judiciary, at least internally, to develop relevant protocols and policies, written protocols and policies that govern the different aspects of the rules, for example, performance standards. Some of these should also be made public. And I'm speaking specifically, for example, about something like judgment delivery, because that is a big, big problem with the public. And so that's something that we recommend. President,
Sure. What I would say is that, and I'm addressing this now to the Court of Appeal, these rules invest a lot of discretion in trial judges. And throughout the session today, we spoke a lot about the judges, the trial judges managing the cases. Part 25 and 26 speak about the court's powers of case management. if and when there are appeals on procedural issues, I urge the Court of Appeal to not second guess the judge too much, to allow the trial judges to exercise their discretion, not to cripple the exercise of their discretion. Of course, if a judge acts completely outside the discretion given them in the rules, then of course you have to bring them back to order. But what we have to try and guard against is courts of appeal overturning decisions of the judges who are exercising their discretion only because the Court of Appeal thinks that if they were in the judge's position, they might have exercised their discretion differently. The rules require an enormous exercise of discretion on the part of the trial judges. And appeals should not be encouraged against the exercise of that discretion unless the judge has really gone completely outside the framework of the rules. So that would be my contribution to this area.
Adrian, I will go to a second round.
Yeah, sure.
Comment.
Mhm.
One should not underestimate the importance of the registry and the court office in this exercise. And I think the court should definitely have a policy for empowering and strengthening their capacity in whatever way is possible. Because to a large extent, they are the face of the court in dealing with litigants and attorneys. And their knowledge and courtesies and support systems are critical to the success of the rules. And you also need to have them, particularly if you're going to move towards paperless systems and electronic filings. The court office is going to have to be empowered to be able to help litigants, self-litigants, to comply with the regulatory framework of the rules. So this thought really is the empowerment of the registry and court office.
Okay,
I don't. Are you doing an entire second round, or time is against us? No. I'm just. You
Yeah.
know.
We have about
We-
2 more
we-
slides to go.
I think we need to wrap up probably no later than 7 o'clock.
Yeah.
So
Okay, that's
I'm gonna take your last 2 slides and then let's wrap up.
yeah. Okay.
So we don't entirely lose our audience.
Okay. Let's go to the next slide, Larissa.
Thank you.
Okay, well, we've been talking about this throughout. The rules would require fundamental changes in the way in which civil proceedings are conducted, and all that we've said really leads to that that conclusion. As we stressed at the outset, the culture, the way we go about doing things is what is critical. We can have the rules, but operate them in the same way that we operated the old rules, and then nothing will change. The rules will not produce the kind of results that they were intended to produce. So it's just, you know, for us to concentrate on, and I want to say this, these rules are written, there are a lot of things which Lord Wolf, of course, you know, these are the Wolf reforms. And we in the Eastern Caribbean were lucky, and Trinidad too, because we had one of the judges who worked on the Wolf Commission, Judge Richard Greenslade, who helped to do some of our initial training. And the point that he kept making is that deliberate attempts were made, and I think Sir Brian referred to them at the outset, to signal a change in culture. They don't talk about rules so much, they talk about part 1, part 2, part 26. The rules are written in a very easy, user-friendly manner. All of these subtle things are intended to bring home that this is a different paradigm. And so training on these new rules is not so much a question of part 1. Part 1.1 says that, part 2 says that, part 3 says that, part 4, rule 1 says that, 2 says that. It's more about grasping what is the ethos, what is the central thread that runs through the rules, and understanding that. And it is after you understand that you can now read the rules in the context of that ethos and get a full appreciation of them. Next slide. Where do you go from here? Okay, this is our last slide, I think. So Dennis?
Yes, President.
Well,
Last slide.
Yes, just a minute. I think that this is the beginning of the road. I think it's an exciting journey. I certainly, although I was not a trial judge when we started our rules, I too got a great degree of pleasure in seeing them operate and trying to help to make them become more fully accepted in our jurisdiction. And so I hope that you will have the same journey in the Bahamas, and that you will see practical results, a reduction in delay in the judicial performance, the elimination of your court backlogs, and improved trust and confidence from the public. So I wish that is where your journey takes you.
Peter, any last thoughts?
Yep, my last thoughts are that I think with the CPR, judges, the court office, attorneys can find a new level of fulfillment in the work they do. I think they could find new levels of motivation and inspiration in the work that we do, which is the delivery of judicial services for our people, our citizens. And I think when Sir Dennis talks about public trust and confidence, I think when a civil justice system can deliver justice in a way in which our people feel trust and confidence, then we as the performers in this arena just feel good about ourselves. And that's something that we don't speak about enough. The personal and professional fulfillment that we have, and that these rules offer us the opportunity to experience.
Okay, thank you. Sir Brian, it was a pleasure for us to conduct this initial training session. As we stressed, there would need to be more, and we have planned more. I think the next one is on March, when is it?
March the 2nd.
March 2nd. So we shall be in touch with you again on that date, and we look for one thing that we didn't do, which we fell down on, and that is to provide you all with an evaluation sheet.
Yes.
So that you could let us get some feedback as to the manner in which the session, whether we achieve the objectives that we had set at the outset. But that's something perhaps we will make up for.
Couldn't Peter send a sheet to the registrar for distribution?
Yes, we can work on that. Larissa, you and I could talk about that tomorrow.
Sure, President.
Okay, okay. So, Sir
Yes.
Brian, over to you.
Well, thank you very much, Sir Dennis, President Saunders, and Mr. Justice Jamador. Speaking for myself, and I'm confident I speak for others, you've given us an excellent foundation at the macro level, which has set the scene for us now to do a deep dive into the various aspects of the rules. Your practical experience is extremely useful and insightful. And I myself think the session has been extremely productive. And I hope that my colleagues will agree with me that you've given us a great launch into this 12-session training program. It's so important to understand the context before we get, as you say, into what does this rule do or what does that rule do. And I cannot think of three more qualified or experienced persons to do that than the three of you. And I'm very grateful for your help and your assistance. And I look forward to your continued collaboration with us as we work through the balance of the sessions. Certainly, if you are able to put together an evaluation form, if you send it to me or the registrar, we'll make sure and get it out to everybody with the help of the bar. A few housekeeping matters. There were a couple of questions in the chat group which we didn't get to. Please don't be offended. We'll see if we can pick those up at some point during the next session. Secondly, we will fix our problem with the 100 limitation. We'll make sure that going forward, we have a Zoom program which can accommodate up to 300 people. So we'll be able to accommodate everybody that wishes to attend. Third housekeeping point, we will be circulating, with the help of the bar, we'll be circulating a training program before the end of this week, setting out the dates and the subjects of the 12 sessions. I have the president here. I know you'll help me. We'll send it to you, and hopefully you can get your office to blast it out to all of the lawyers. So people will be able to make their plans and hopefully plan to attend all of these sessions, or as many as you can. Any feedback that any of you have, please feel free to send it to me directly. You all have my email address, so it's on the website if you don't have it. So you can send it to the registrar. We welcome the feedback. I would like you to consider and discuss amongst yourselves before the next session the issue of costs. This came up. President Saunders has invited us to consider the current draft, and I certainly want to discuss this with the bar and get your feedback. Specifically look at prescribed costs. You will find those are dealt with in the Guyana rules, in the Barbados rules, in the ECS rules, and in the Jamaica rules. So there's lots of precedents for you to look at. And hopefully we can discuss that and decide what's best for us. Last point, you heard me say earlier that the Rules Committee opted against adopting the pre-action protocols. I would like the bar's feedback on that. Is that a good idea or a bad idea? Pre-action protocols have specific objectives. That's a subject which I would like some feedback on from the bar as well as we go forward. So, Mr. President, you have President of the Bar, Mr. Parker, you have any closing remarks?
No, I would echo your sentiments, and I would also invite members to send any contributions or queries to myself as well, so that we can engage with the Chief Justice on the subject. I would like to thank our presenters. They performed as I expected, and we are very grateful for their contribution to our journey with the CPR. And I look forward to seeing you all at the next session. Thank you very much. And I'd like to thank members for coming out and participating in this exercise. It is through your engagement that we will get the best rules possible and get the best start possible on our new journey.
Yes, thank you, Mr. President. And I too wish to express my gratitude to all of the participants. It's a very encouraging start to our process. Let's see if we can have 100 plus at session 12 as well, when we'll all be exhausted. But stay with us throughout the process. So on that note, thank you again. Special thanks to President Saunders, to Dennis, and Mr. Justice Jamadar. You've done a great job. I knew you would, and I'm sure going forward, your sessions are going to be equally as helpful and as informative. On that note, good evening, everyone. Have a nice evening, and we'll see you on the 2nd of March. Thank you.
Thank you. Goodbye.